Thank you, Mr. Chair and the members of the committee. My name is Miliana Tarai, and I'm the Legal Services Manager for the Fiji Women's Crisis Center. This afternoon, I'm accompanied by my colleagues, Ms. Linda Sende and Ms. Petrina Fremlin, and I also have Ms. Mosmin Dean with me and Ms. Muskan at the back, together with our coordinator, Shamima Ali. This afternoon, we will be making our submission on the Fiji Police Bill number 12 of 2026. So that's the only bill that we will be submitting this afternoon. We also have copies for the committee for ease of reference. Firstly, we'd just like to introduce our organization. The Fiji Women's Crisis Center is a human rights organization which is based on the principles of human rights, democracy, and the rule of law. And we have been in existence for over 41 years. Our goal is to eliminate all forms of violence against women and girls in Fiji and the Pacific in all spheres of life. We implement this vision through an integrated and comprehensive program designed to prevent and respond to violence by reducing individual and institutional tolerance of violence against women and girls and increasing available and appropriate services for survivors. We address the problem of violence against women and girls using a human rights and development framework, and it focuses on human rights, which includes a feminist analysis of the problem, and it permeates all aspects of our work, recognizing that the root causes of violence against women and girls are unequal gender power relations embedded in patriarchy. We are also the secretariat for the Fiji NGO Coalition on Human Rights, a coalition that has been in existence since 1998. We acknowledge and we welcome the recognition of gender, human rights, and professional development training provisions within the Fiji Police Bill 2026. We also recognize that the bill represents an improvement from the previous legislative frameworks, particularly in its incorporation of several important human rights safeguards and modern policing standards. These developments reflect an attempt to a positive shift towards a more rights-based and professional policing environment in Fiji. It also reflects a meaningful effort to strengthen public trust, improve professionalism within the police force, and align the legislative framework with current policing expectations. However, we remain concerned that despite these advancements, the bill continues to contain provisions that raise fundamental human rights and accountability gaps. In particular, the use of broad, vague, and undefined terminology in several sections, which creates a risk of inconsistent interpretation and application, and may unintentionally expand police powers beyond what is necessary or proportionate in a democratic society like ours. Our concerns are addressed under the following themes. The first one is accountability, oversight, and transparency. Our second point is on human rights. The third one is on use of force and safeguards against abuse of power. And our final theme will be on professionalization, community trust, and gender-responsive policing. We therefore submit that further refinements are required to ensure that the bill is precise, rights compliant, and fully aligned with constitutional and international human rights standards. So on our first point of accountability, oversight, and transparency, we would like to address Section 148 of the bill on the offense of disaffection. One of our concerns is with regards to this particular section, 148, which appears to mirror Section 91 of the UK Police Act, which is now considered as part of an outdated UK legislation. While maintaining discipline within the Fiji police force is important, the use of the term disaffection is overly broad, vague, and subjective. The provision creates a risk that journalists, trade unions, civil society organizations, human rights defenders, and members of the public could be accused of causing disaffection merely for criticizing police conduct, policing institution, exposing misconduct, or advocating for police reform. Therefore, even encouraging a legitimate debate, protesting working conditions within the force, or advocating for internal reform can be classified as an act calculated to cause disaffection. For the UK police, their corresponding provision ensures that police lack the fundamental right to strike, to take collective industrial action. In other words, police officers in the UK can face potential prosecution for simply suggesting or appearing to encourage a strike or a work to rule whereby a withdrawal of goodwill is done by police officers. The lack of a clear definition of disaffection also can act as a deterrence for officers from publicly whistleblowing on corruption, underfunding, systemic failures within their own forces, complaints of sexual harassment and domestic violence, and crimes against women within the Fiji Police Force. This section also has an alarming effect on public participation, freedom of expression, and legitimate scrutiny of policing institutions by the public. Accountability in democratic societies depend on the ability of individuals and organizations to openly discuss concerns regarding police conduct without fear of prosecution. The supreme law of the land, Fiji Constitution, guarantees our rights to freedom of expression. Similarly, Fiji has ratified the ICCPR, which also has these rights. As a signatory to this convention, Fiji has an obligation to honor it. The public must be allowed to scrutinize the Fiji Police Force and speak freely to hold them accountable for their conduct and miscarriage of justice when it happens. In the same way, such scrutiny and genuine concerns of the public was also a way in which the no-drop policy came into existence. Therefore, we recommend reviewing the entire provision of Section 148, as this section in its current form can be weaponized by the state and the force to neutralize police labor rights, civil liberties, and the police force being held to account. Our next concern is with regards to Section 161 on the protection from liability. We acknowledge the need to ensure that police officers are able to carry out their duties without the fear of constant litigation and to prevent defensive policing. However, Section 161 of the bill raises concerns regarding accountability because it provides broad immunity from civil and criminal liability in circumstances when officer acts in good faith by following a warrant or order which appears to be lawfully issued. This section creates a high evidentiary threshold because acting in bad faith requires more than just negligence, incompetence, or a simple mistake, which could have been easily avoided. Furthermore, this also gives room for the police force to claim that they owe no duty of care to individual citizens. For example, in instances where they fail to prevent a crime or properly investigate one. The phrase appears to be lawfully issued is also overly broad and may shield officers from accountability, even where warrants or orders are erroneously given or were maliciously procured or based on bad intelligence or where constitutional rights will be allowed to be violated. Similarly, the use of terms such as good faith in Section 161 and by any means in Section 57 lacks sufficient precision and creates uncertainty regarding the limits of police powers and protections. Therefore, we submit that the bill should make it clear that immunity does not apply where officers' actions are negligent, reckless, use excessive force, corrupt, based on a warrant, summons, or order which was maliciously based, or based on bad intelligence, or where they knowingly violate constitutional rights. Such amendments would ensure that officers acting legitimately remain protected while preserving accountability for serious misconduct and abuses of power. Our next concern is with regards to the to the police complaints mechanism within the bill. The initial complaints process remains largely controlled by the Fiji Police Force, including senior officers and the Commissioner. While the bill establishes an independent disciplinary tribunal under Section 130, access to this body is effectively dependent on complaints first passing through the internal police screening and assessment processes. This creates a structural risk that complaints may be dismissed, filtered, or resolved internally at an early stage without independent scrutiny. While the bill provides for an independent appeal avenue for complainant whose complaint has been summarily dismissed by the Commissioner, it does not rule out the fact that this arrangement positions the FPF as a gatekeeper to its own accountability mechanism, and this undermines independence, transparency, ethics, and public confidence in the complaints process. We therefore submit that this model does not adequately reflect international best practice in police accountability. Comparable jurisdictions have moved towards independent complaint intake and investigation systems that are civilian-led, gender-balanced, and are structurally separated from operational police control. For example, the Independent Office for Police Conduct in the United Kingdom or the Independent Police Conduct Authority in New Zealand that are institutionally independent from the police and the government and has the authority to receive complaints directly from the public, initiate investigations without police referral, and conduct independent oversight of police misconduct matters. Independent oversight provides assurances for both the public and police that allegations of misconduct or neglect of duty will be properly dealt with, without having to waste the complainant's time and resources in their search for justice. This also ensures that citizens are protected from abuse of those in power and from excessive use of force, encourages discipline within the police force. It will also improve policing practices and systems, protects against politicization of the police force, and ensures that there is a safe and just society. We therefore recommend that the bill be amended to provide a direct statutory right of access to an independent, civilian-led, gender-balanced complaints commission, which should be funded by government, operationally independent of the police force and the executive. Such a body should have clear statutory powers to receive complaints directly from members of the public, conduct or direct independent investigations into police conduct, compel evidence and witness cooperation, refer matters for prosecution or disciplinary action where appropriate. We further submit that this reform is necessary to address systemic institutional gaps within the policing framework. Effective oversight must not depend on internal police discretion at the entry point, particularly in cases involving allegations of serious misconduct, including excessive use of force, deaths in custody, corruption, violence against women and girls, torture, or abuse of authority. Strengthening independent complaint intake and ensuring direct access to oversight mechanisms would significantly enhance transparency, improve public confidence in policing institutions, and also align Fiji's legal framework with emerging international standards of democratic police accountability.
Our next area of concern is on human rights. The bill lacks privacy and civil liberty protections. By failing to do so, this bill empowers the Fiji Police Force to carry out acts that can encroach on the preservation of human rights and democracy. This poses a real danger to the spirit of democracy, human rights, and the rule of law for our nation. Our first issue is on Section 87 to 91, access to digital devices. We acknowledge that digital evidence has become an important component of modern criminal investigations. However, Section 87 to 91 raises significant human rights concerns because they grant police broad powers to compel access to digital devices, passwords, information, and technical assistance, with non-compliance constituting a criminal offense. These provisions contradict important rights protected under the ICCPR, including the right to privacy under Article 17. Combined with a broad definition of specified person under Section 87, these powers can extend beyond suspects and allow significant intrusions into the personal privacy of citizens. Digital devices contain extensive personal information, including communications, financial records, medical information, family photographs, and confidential correspondence. Without significant safeguards, these powers create a risk of interference with privacy rights and enables the potential abuse of private data, and it also undermines freedom of speech and association. Knowing that the police can access your digital devices and read through private messages, and such histories can act as a barrier for citizens not to express controversial thoughts or critical thinking. This can cause citizens to avoid being affiliated with certain groups of people or attend protests which they know attracts police scrutiny and monitoring, especially in honor of bilateral relationships with other countries. We recommend that the bill include stronger judicial oversight by ensuring that the Fiji Police Force must establish a clear nexus between the specific device, the crime under investigation, and the specified person. The application must also show cause on all other non-invasive efforts that have been employed, and that an application for digital device access is the last resort. A warrant must be narrowly tailored to only search for specific relevant data in order to avoid exploratory fishing expeditions. There should also be clearer limitations on the use of required information, duration for the digital device access, protection of data and its use, and safeguards. These would assist in balancing legitimate law enforcement objectives with the protection of fundamental rights. Our third area of concern is use of force and safeguards against abuse of power. Our first issue under this section is section 57 to 67, covert surveillance and tracking powers. We acknowledge the importance of surveillance and tracking powers in the investigation of serious criminal offenses. However, section 57 to 67 grant extensive powers to conduct covert surveillance, intercept communications, utilize tracking devices, and enter private property, including by force in certain circumstances. These powers constitute significant intrusions into individual privacy and therefore require particularly strong safeguards. While the bill requires warrants and consideration of the seriousness of offending, we remain concerned that oversight mechanisms are insufficient and impartial. Impractical, my apologies. The bill does not establish an independent oversight body responsible for reviewing surveillance activities. It also does not require post-surveillance notification in appropriate circumstances, and the bill contains limited transparency requirements regarding the use of these intrusive powers. We are particularly concerned about Section 63 relating to applications for covert or forcible entry warrants. Given the significant intrusion in an individual's constitutional right to privacy, applications for such warrants would be subject to stronger judicial scrutiny. We recommend that applications require both detailed written and oral submissions before a court, which can also be heard in chambers to ensure careful consideration of necessity, proportionality, and potential human rights impacts or breaches. Section 62 is also concerning because it allows the Fiji Police Force, particularly a senior officer, to authorize the placement of a tracking device on or in a citizen's vehicle, craft, or goods. It is further concerning that such an authorization is based on a suspicion or belief that the tracking device will expedite a covert operation. This poses a severe threat to civil liberties and gives the Fiji Police Force unchecked powers to monitor the movements and private details of citizens. Without a judicial oversight, it allows such surveillance to be carried out on political whims, bias, and unfettered police discretion, which undermines the protection of citizens' rights under the Constitution. Further concerns arise regarding the management, holding, and protection of information and data obtained through surveillance activities. The bill does not adequately address who will control the data collected, how long will it be held, what security measures will be implemented, or what penalties will apply where confidential information is improperly disclosed. Given recent public concerns regarding the unauthorized release of sensitive information, including postmortem reports and photographs, stronger safeguards are necessary to ensure confidentiality, data security, and accountability. We therefore recommend the establishment of independent oversight mechanisms, stronger judicial safeguards, enhanced reporting obligations, and clear statutory requirements governing the procedural collection, storage, use, and destruction of surveillance-related information, given that the information collected and stored can be used to threaten or track people. Our other issue on the same topic is strengthening use of force, reasonable force, and use of arms provisions. We note the recent statement by the Ministry of Policing on the 18th of June this year, confirming that there are currently no plans to routinely arm police officers with firearms. Despite existing legal provisions allowing officers to carry firearms when necessary, while we welcome this position, it remains deeply concerned that even in the absence of routine firearm use, Fiji continues to experience a troubling number of deaths, serious injuries, and allegations of torture and ill treatment rising from police operations and detention settings. The deaths of Filikesa Soko and the assaults suffered by Rajneel Singh demonstrate that the greatest risk to human rights violations in Fiji is not necessarily the use of firearms, but the misuse of physical force, excessive restraint techniques, custodial violence, and the absence of effective accountability mechanisms. These incidents highlight the urgent need to ensure that the Fiji Police Force officers are not given the power to use arms. The right to life is protected under Section 8 of the Constitution of the Republic of Fiji, which guarantees that every person has the inherent right to life and must not be arbitrarily deprived of life. This protection is further reinforced by Article 3 of the Universal Declaration of Human Rights, which provides that everyone has the right to life, liberty, and security of person. Any use of force by police officers must therefore be strictly regulated and exercised only in a manner that is necessary, proportionate, lawful, and accountable. In addition, reasonable force should only be applied when there is an imminent threat. This will ensure the balancing of police response, civilians' rights, and the pursuit of justice. International best practices demonstrates that strong legal safeguards and detailed operational guidance significantly reduce excessive force and police-related deaths. The Convention Against Torture Initiative Police Resource Toolkit on the Useful Use of Force notes that all use of force must comply with the principles of legality, necessity, proportionality, precaution, non-discrimination, and accountability. The toolkit further emphasizes that force should only be used where non-violent means, such as persuasion, negotiation, and mitigation, have proven ineffective, and that force must also be the minimum necessary to achieve a legitimate enforcement objective. The toolkit also highlights examples from the United States and the United Kingdom where police agencies have prohibited dangerous restraint techniques such as chokeholds and fog tying because of their association with deaths and serious injuries in custody. The toolkit further identifies comprehensive training, mandatory de-escalation techniques, scenario-based exercises, regular refresher courses, post-incident medical care, detailing reporting requirements, independent investigations, and public transparency as essential safeguards for preventing excessive force and protecting human rights. Fiji has had a checkered history in terms of guns. Similarly, the Fiji Police Force has also had a checkered record of guns and use of force as far as violence and brutality is concerned. In light of Fiji's history of deaths and serious injuries occurring in police custody and during police operations, we consider it essential that the Fiji Police Bill contains stronger and more detailed provisions governing the use of force, reasonable force, restraints, and the use of arms. We recommend that the use of arms should only be used in situations where there is a threat to national security, and that there should be a specially trained unit that undergo continuous intensive training on safe and responsible use of arms, according to the conventions and UN guidelines Fiji has ratified. The legislation should establish clear legal thresholds for the use of force, require that force be used only as a last resort, prohibit force that is punitive or retaliatory in nature, mandate stronger de-escalation whenever possible, require comprehensive and ongoing training for all officers, and provide a mandatory reporting, independent investigation, and public accountability whenever force results in serious injury or death. Such safeguards are necessary to uphold the constitutional right to life, prevent torture and ill treatment, and restore public confidence in policing.
Our final area of concern is professionalization, community trust, and gender responsive policing. Our first section of concern is 152, which is failure to assist police. We are concerned about section 152, which creates an offense punishable by a fine of up to $5,000 for failing to assist police when requested. While there may be circumstances where public assistance is necessary to protect life or prevent serious harm, the provision does not adequately recognize the legitimate safety concerns faced by many members of the public. This section fails to provide sufficient protections for elderly persons, persons with disabilities, pregnant women, caregivers, women in domestic violence situations, individuals suffering from illness, and persons who may face retaliation or violence as a result of assisting police. Due to Fiji's criminal climate, individuals who assist police may subsequently be exposed to intimidation, threats, or violence within their community. Criminalizing a person's decision to prioritize their own safety, as well as their family safety, may discourage trust and cooperation rather than actually strengthening it. We submit that the bill should recognize a person's right to refuse assistance, where doing so would place them at risk of physical harm, retaliation, or undue hardship. Explicit exemptions should be provided for disability, illness, pregnancy, domestic violence situations, caregiving responsibilities, and other areas affecting vulnerability. The bill should also require officers to explain why assistance is necessary and how any risk to the individual will actually be managed. We further note that the proposed maximum fine of $5,000 appears excessive and may disproportionately impact vulnerable members of the community. Consideration should be given to adopting a more proportionate penalty framework consistent with comparable jurisdictions such as New Zealand, where the fine for not assisting police is a fine not exceeding $2,000. It should be noted that community trust is best built through voluntary cooperation rather than coercion. Our next section is Section 9, Powers of the Minister. We recognize that Section
129, subsection 6 of the Constitution permits the Minister to issue general policy directions to the Commissioner of Police. However, neither the Constitution nor Section 9 of the bill clearly defines the limits of ministerial directions. Public confidence in policing depends upon the operational independence of the Fiji Police Force and the perception that policing decisions are free from political influence and can work independently. Moreover, it is crucial that the government and its ministers or the minister in charge of policing does not have a powerful standing or interference powers in the Fiji Police Force to ensure and allow the force to work independently, maintain law and order without political interference, preserve peace, safety and security for all individuals, and protect the rights of all individuals. We therefore recommend that Section 9 expressly state that ministerial directions must not relate to individual investigations, arrests, charging decisions, surveillance activities, prosecutions, or operational policing matters. Such an amendment would strengthen institutional independence, promote professionalism, and ethics. Maintaining a clear distinction between policy oversight and operational decision-making is essential for preserving public trust in the impartial administration of justice. In conclusion, we reiterate its acknowledgement of the significant progress made in the Fiji Police Bill 2026, particularly in strengthening training provisions, introducing improved safeguards, and demonstrating a clearer commitment to human rights and professional policing. Reforming the Police Act is not just a timely matter that needs updating, but it is necessary, and these reforms represent an important step forward in modernizing Fiji's policing framework and enhancing public confidence in law enforcement institutions. We submit that policing responses must always be responsible and consistently grounded in human rights and the rule of law. Such compliance, especially where human rights is concerned, is not a barrier to enforcement work. Instead, it is a measure of institutional success. We emphasize that meaningful accountability and effective human rights protection cannot be achieved where key provisions remain broad, ambiguous, or overly lenient in scope. Without clearer definitions, stronger independent oversight mechanisms, and strong safeguards against misuse of power, there is a continuing risk that well-intentioned reforms may be undermined in practice. FWCC therefore urges that the bill be further strengthened to ensure clarity, precision, and strict compliance with constitutional protections and international human rights standards. In doing so, Fiji can ensure that its policing framework not only supports effective law enforcement, but also fully upholds the rights, dignity, and safety of all people. Thank you.
Naka, thank you very much, ladies, for the submission from FWRM. Navale, for your submission. The members may have some questions or comments. If I can just start, if I can just start, Honorable Koya. On the screen, ladies, says 48A. What is the stance of FWRM on 48A?
Sorry, sir, it's FWCC.
Oh, my apologies, FWCC. My apologies. What are your thoughts on 48A, which is being introduced in the bill to grant powers to the Justice of Peace to issue general search warrant?
That particular power it's in the current act, and that's what the police are currently using as well. Usually for general search warrant, they can go to JP or a magistrate. But as we have mentioned in our submission, when it comes to such warrants, there is a need to have judicial oversight over it. It has to be strengthened. You can't just give unfettered power to the police, to carry out their operation in any way that they would want to. And justices of peace are not really part of the judiciary, which is why most of our submission contents today has been around strengthening judicial oversight when it comes to asking for warrants.
Thank you. Thank you very much for your submissions. My question is, I've actually got two questions. The first one is relative to Section 11, and this is with respect to the delegation of the commissioner's powers. If you look at it, it basically says the commissioner may delegate any of his powers, duties, or functions under this act to the deputy commissioner, which is fine, but then it goes on to say, or a police officer. Do you believe that should be changed, or what's your position on something like that? Because as it stands right now, he could give it to anybody
Within the rank and file.
within the rank and file of the police force. He can delegate his powers to any police officer. Your thoughts on that?
Well, definitely, that power should not be easily given to just any police officer. As you would have also been hearing from our submission this afternoon, even the fact that, it's a senior police officer who has to make applications or give authorization of some sort when it comes to warrants, for us, that is a problem. So, yes, we believe that Section 11, that needs to be removed from the police officer. It's understandable if it's a deputy commissioner who usually steps in when the commissioner is not available, but not for a police officer.
The second part of my question is relative to Division 9. In fact, the whole of the division is relative to forensic procedures. As you would understand, when it comes to forensic procedures, those that are involved in forensic procedures are independent people. Do you believe that this entire division should sit within the Police Act, or it should be of something of its own standing? It's an independent organization. Do you believe that it should sit within the Police Act because of the perception that it may create?
This was actually something we were just thinking over before we came in. If it is possible, we would be handing in our full written submission, and we would also try and look into that in our final submission.
Very well. Thank you very much, ladies. On behalf of the committee, thank you very much for making a submission. Navaliw, sir. Have a great
Thank
afternoon.
you.
Naka. Naka. Kaya sarang nila. Sa give me warning, thank you sarang. Kung ito lagi. Kaya sarang nila, pwede betul lagi, pwede lulu ni on sa kanalay. Naka. Yes. Set. Karen. The morning in Bua. Now, we'll be back again to the team from SWN. A very good afternoon to you all. Thank you very much for coming in again this afternoon to make submissions. We won't take too much time as we were here yesterday. I'll hand over the floor now to probably Mr. Nawikula to take lead on the submission of the team.
Thank you, Mr. Chairman. My name is Nico Nawaikula, representing SWN. Again, our submission today is a joint submission by SWN Advocacy and Labetia Navanua.
Gentlemen, my name is Kalokalo Loki. I'm the chairman of the Lavetia Navanua. As Mr. Noikula said, today it will also be a joint submission for SWN Advocacy and Lavetia Navanua. Naka.
Now, I'd like to introduce myself again as Pioroa from SWN and part of the the Winnikeli Council that we are building on to structure things for the Itoke and the Vanua Winnikeli Vinaka.
Good afternoon, Faith Grace, supporting here for SWN Naka.
Thank you, Chairman and members. I will, firstly, we have two submissions on the Indigenous Rights Bill. The reason for that is that I had prepared one and another one was comments in relation to that, but because of the shortness of the time, we will submit them both. So, and hand over to Mr. Jackson to scrutinize the points that we raised. So, our submission would be on the Indigenous Rights Bill number 37 of 2025. I think I will skip the introduction, explaining who we are and who Lavitiana Vanua is, as we have explained that yesterday. So going right to the bill, this is a copy of the bill. And when you read the bill, the first thing that comes to mind is that, do you need an act of parliament to tell you to do what you can do even without it? Namely, in this case, UNDRIP. And that's the whole question in relation to that. Because, and the answer to that is, in our instance, yes. Because without that, you are left with political will. And for example, Fiji has failed seriously on its willingness, political willingness, to enforce or recognize aspects that it ratified in relation to UNDRIP and also ILO C-169. For example, village bylaws is a group right, and village bylaws has been removed in 1967, 59 years ago. We ratified ILO C-169 in 1998. And ILO C-169 recognized a group rights is a right for indigenous people to have customary laws, to enforce their custom by their own way of sentencing, judicial. So if you take it from 1967, when it was removed, to the Rambuka government of 1990 to 1997, then Ngarase from 2002 to 2006, and take 16 years of total lack of political will. So that's the good part about this, because this allows the government to be accountable to address what it has ratified in a convention. Take another example. Another group right is the right of prior and informed consent before passing any legislation. And you ask yourself, has that been enforced? And the answer, in a whole, is no. And very sad, 2013 Constitution even removed that. Removed the right of prior and informed consent before, of indigenous people, before you amend any legislation that affected. 26 anti-Tauke laws were just passed. Were the indigenous people consulted? No. Was there prior and informed consent given? No. And then you ask, Fiji had ratified ILOC 169 in 1998, which makes it a requirement that any government, before it passes or amend any law that affect indigenous people, for example, Native Lands Act, Fijian Affairs Act, it has to obtain their prior and informed consent. And worst of all, the 2013 Constitution removes that, purposely, we say. So coming back to the bill, so the way we see it appears that Fiji is following some countries, including Bolivia, New Zealand, Canada, Philippines, Norway, and others, in trying to bring down the obligation of UNDRIP to domestic law. That is a good thing, and that's an advantage of this. But it should be an excuse by government to say, we have not addressed this because we need to pass this first. No. You have that political willingness, and you don't need an act to tell you to do what you've already promised the UN to recognize by ratifying ILOC 169 in 1998 and UNDRIP in March of 2023. But we see that the closest parallel, and I think this has been a cut and copy, but not a very good effort in that, is Canada. So if you look at the Indigenous Rights Act of Canada, 2021, you will see that this one follows it nearly word for word, but a very, very bad effort, because the situation in Canada is totally different from the situation in Fiji. So if you make the comparison of this bill and Canada's 2021 Indigenous Rights Bill, Section 4 of the Canadian Act affirm UNDRIP as an international human rights instrument, understanding, of course, that when you ratify a convention, for example, human rights and things like that, you don't actually, you are obliged to make the further step of transmitting that to the domestic law. And many times, those are not done. When those are not done, you are left with the mechanisms within those conventions of how to enforce it. So Section 4, Canada affirm UNDRIP and provide a framework for implementing the declaration in Canada and support reconciliation and respect on Indigenous rights. This is Canada. That's Section 4. Section 5 says the Government of Canada must take all measures necessary to ensure federal laws are consistent with UNDRIP. Let me just say this: I don't see that in the bill. And then Section 6, government must prepare and implement an action plan to achieve the objectives of UNDRIP. The plan must be developed in consultation and cooperation with indigenous people. And that's Section 6. Also, in Fiji's section, but badly written, because once you affirm UNDRIP, you don't need to put those other things there. You're simply importing the whole convention into domestic law. In Fiji, it lists another 6 other things, unnecessary and should be taken out. Then it says the plan must be developed in consultation and cooperation with indigenous people. But if you look at ours, it only says it has to be developed by the GCC and Fijian Affairs Board. Totally wrong, because our situation in Fiji is that we are a majority, and there are other communities. And we should also hear their views before you do any policy. So let me put that in an example. In 2012, when I submitted in Geneva, Human Rights Committee third on the anti-Tauke laws, including surfing decree and the one that terminated the GCC. Before I stood up, the representative of the government was first to stand up, and he told the committee, Fiji does not recognize indigenous rights because they are a majority. And the reply that came from one of the committee members is that you are wrong. What about Bolivia? What about Guatemala, where the indigenous are majority there? What you should do is recognize indigenous rights to its full extent. Also recognize fundamental human rights to its full extent. Recognize also the rights and interests of other communities to its full extent. And the task for the government is to balance that so that none topples the other. And just by way of example, one example of balancing rights is consider the Native Land Trust Act and the Native Land Trust Board. Itoke in this country own 91% or 94% now of the land, and the other communities have none. So to balance that, we have the Native Land Trust Board, where Ratu Sukuna, in his right mind, created the reserve for exclusive use of Itoke, and outside reserve, we have equality of access. Itoke, Chinese, Indian, you have equality. So that's an example of balancing rights. And coming back to this, you don't need only the views of GCC and and the Fijian Affairs Board. You need the views and contribution of other communities. So that needs to be looked at also. Section 7, this is on Canada. This is on annual reports. What I'm doing is that I'm looking at Canada and I'm making comments at the same time. The responsible minister must report annually to Parliament progress. Now, you look at Fiji, I was saying this is a cut and paste from the Canada. Section 3, objectives. Affirm the declaration as a universal international human rights. Okay, that's fair enough. And then you have what I regard as unnecessary things. Promote self-determination, combat prejudice, promote virtual respect, establish measures for monitoring, recognize. In my view, unnecessary. And just do it like Canada did, just one sentence. Just affirm that the Declaration of International UNDRIP is a universal international human rights for Fiji. Then, Section 4 reaffirms the declaration as a means to promote indigenous rights in Fiji. And I said that one is badly drafted. Then, number 5, directs the minister in consultation with the council and board to prepare action plan to achieve the objectives that must be tabled in Parliament. Again, a copy from Canada, an annual report, that's also. So the good thing about this bill, again, is that it attempts to force government, whatever government. If the coalition goes out, and if this is passed, whatever government that comes in, because it's an act of state, he will be obliged to prepare that scheme in any government to address and incorporate UNDRIP into Fiji's national laws and government policies. That is a good thing. But the bad thing is that it is a very poor attempt, and therefore we recommend further discussions. To illustrate, you cannot simply compare Canada to Fiji. Fiji has a totally different set of facts from Canada, New Zealand, and those countries. Fiji has a well-recorded history of protection and recognition of land rights. For example, Native Lands Ordinance of 1905, Native Lands Act of 1940, and recognition of cultural autonomy. For example, the Mountain Titoke and Fijian Affairs Act. UNDRIP only came in 1993 or something. These were recognized for Fiji in 1874, the land rights and the rights to cultural autonomy. So it's totally different from New Zealand. New Zealand, the Treaty of Waitangi only became law in 1975 under the Treaty of Waitangi Act. In Fiji, the terms of the deed of cession were transmitted into domestic law in relation to land rights, 1882 Native Lands Ordinance, in relation to the right for cultural autonomy, the 1876 Native Affairs Ordinance. Long time. So you cannot compare Fiji with Canada. And the challenge for Fiji has always been on how to empower indigenous people to utilize their land and their natural resources, as well as their right to self-determination and the culture of them, into well and increase their standard of living. So it's a different, we have a different challenge to Canada. They are just recognizing it. Currently, 75% of those living below the poverty line are indigenous Itoke. But their rights to land has been recognized. Their rights to cultural autonomy has been there for over a century now. And the challenge has always been how to empower that, so that they can utilize their land, they have to increase their standard of living. Currently, the biggest priority has been to restore village bylaws to ensure custom, law, and order, and how to empower utilize their 90% of the natural resources. So we feel we really need to take this law back to the drawing board and to consider it in the light that is unique to Fiji, and not just copy Canada. Because Canada is doing that because the indigenous peoples there are a majority. The health standard has always been on the periphery. So it needs to bring them up very quickly by having every government obligated to address those issues. In Fiji, we want to do this to wake up whoever's in government to address what they should have addressed in these many years. That is basically the gist of what we are asking, but just looking at some of the deficiencies of how this thing is drafted. If you look at section 3, we are saying once you affirm that UNDRIP is human rights, you don't need to list those other things. They are redundant. They are OTOs. Section 4, Section 4, you must have in this legislation an express provision that says when you address indigenous rights, you must balance it with the rights of other communities to make sure that none topples the other. That really is what indigenous rights should be for Fiji. It's different from how New Zealand, how Australia, where the indigenous peoples there are a minority. They can afford them full recognition. But in here, we must always balance our rights with the rights and interests of other communities and fundamental human rights, and that must be expressed in any provision of any law that addresses indigenous rights in Fiji. And on Section 5, I've already said that provision in Canada is not here, where there's an obligation to look at all the laws to make sure they are consistent with the imperatives and directives of ILOC 169 and UNDRIP, prior and informed consent, for example, etc., etc. And again, those are missing from the. So, in conclusion, to conclude, we feel that the Act is good because government is lazy. History tells us that government has no political will to address the group rights of indigenous people, and putting it into the Act obligates the government of the day to address that. But the current attempt, which appeared to follow Canada's model, is very poor and needs further consultation and improvement. In Canada and many other countries, indigenous people are a minority, while in Fiji, they are a majority, and the challenge is that any legislation, for any legislation addressing indigenous, is that it has to, you must balance indigenous rights with fundamental rights and the rights of the other community. Chairman, that's the first one. Let me just, we have a second one. In the second one, we are saying, yes, this legislation seeks to domesticate or transmit the UNDRIP Convention into the domestic laws using the model of Canada, or to be specific, Canada's UNDRIP Act, Indigenous Rights Act of 2021. While the bills intend to compel governments to align laws and policies with UNDRIP is welcome, it requires substantial strengthening to reflect Fiji's unique context, where Itaukei are a majority with deep historical connections to their land. Fiji differs from those countries, and the bill has potential to institutionalize annual government accountability to UNDRIP. However, the current draft is inadequate and requires further consultation and redrafting to address Fiji's specific context and historical protections. Thank you.
Thank you very much, Mr. Nakula, for that submission. Honorable members, any comments or questions? No? No. Honorable Usamat has a question.
I thank Honorable Nawekula for his contribution. I think you're basically saying it's useful, but it's not good enough. So it will help us ideally if you were able to articulate. I know you've talked about a lot of these things that you think that should be there, that can strengthen it. But I think a submission from you on exactly what those issues are would be of great help to the committee. What are exactly those things that you would think need to go in order to strengthen the bill? Written.
Here, government must have engaged a consultant and probably paid 100,000 or 200,000 for that. But for that to come together, it's not only my opinion. You need to consult. But I can tell you the challenge. The challenge has always been how to empower Itaukei to utilize their rights to increase their standard of living, having regard to the rights and interests of other communities. Yeah. The balancing act. So it will be, I think, government will need a committee of experts who will look into that. I can tell you one example now. Even now, you need policies and programs for indigenous people to be focused. And it was set up to be that way by Ratsukuna, where you have the provincial councils. But the provincial councils now are not doing that. The provincial councils now are agents for the government, regional, where all they do is that when the government officials from the agriculture or from housing come to a village, they carry their bag and introduce them and do the same. That's all. But if you look at the act, it says good governance of the people, education, their employment, agriculture. It should be centralized at the provincial office. That's one example. If you can even particularize it, you now have group farmers. I don't think you already have a group there. Don't deliver a caterpillar or digger to this group or that. Deliver it to the provincial office. That's their group, and they can access it from there because they are communally. So those are just examples, but properly convened by government, these things will come up. And we can see experts. Israel is expert in agriculture and communal type of living where you have the kibbutz people. They might have views that will help the indigenous people.
Thank you, Mr. Naikula. Faith, did you want to say anything?
I just have just a few things that I wanted to add in what Honorable Usamate had stated. With the action plan, I'd like to see that, I mean, beginning, you have the rights of the indigenous people. We also have the right to govern ourselves. And for me, I think it's a bit dangerous here with this bill because there's the powers that have been given to the minister. I've seen there that the minister cannot be held accountable for certain decisions that he will make on behalf of the indigenous people. But the minister is appointed from a political party and may not necessarily be what our leaders, the GCC, may want for the indigenous people, or even as indigenous people, as individuals. So I think it's important that we take that back. We need to look at that again. It also gives him the power to choose people to sit on certain boards. That is in the bill. I've seen that. And we need to make sure that everything is being consulted with the GCC. I, for one, think that the GCC should stand on its own. It should not even be part of Itoke affairs because it still comes under government. They should be allowed to act independently on behalf of the indigenous people. That's just my personal view. I'd also like to see, as part of this plan that is to be approved, if we could have entrepreneurship for the youth, the men, the women, for initiatives that can be given there. And the last thing, and also indigenous scholarships there. Also, and the last thing that I wanted to bring up was who supervises the minister. If he's not going to be held accountable, then why do we have the fines and the prison terms? That is for everybody else except for the minister. But we must understand that the minister comes under a political party, under government. That may not necessarily be what the indigenous people want, because he would have to come with what his party wants. And if that goes against who the GCC represent for us, because they are our chiefs. I mean, I'm going to trust our chiefs. And then if they don't act a thing, we've got the provincial council to go through that and hold them accountable. But why isn't the minister being held accountable in this bill? Manaka.
So, Faith, you want the minister to be held accountable?
Well, he should be if what is discussed with the council and the Itoke Affairs Board comes to Parliament and something else is presented in Parliament, besides what they've discussed and agreed to, because they will agree on behalf of the indigenous people, the GCC.
Pio, any comments?
Thank you, gentlemen. Thank you, Mr. Chairman. I'd just like to elaborate a little more on what Mr. Nawikula had expressed regarding the indigenous rights. And I'd just like to bring us as a whole, now coming back home to where to become a traditional leader, we have to follow through with what comes, and we have to address the incapabilities that the youth have and the effects of what's happening nowadays in the modern world with our youth. And I'll bring it up as for where I come from in Taveuni. As we all know, it's the island is about it's 90% freehold land and only 10% native. So we can adjust ourselves to the reality of the population. And the population, so the indigenous peoples in Taveuni, there's more than the land that belongs to the owners of the freehold land. And I bring in the Crown Grant issues, as for example, as I mentioned during the session yesterday, that we are at a loss. We are at a loss because of the structure of the Crown Grant system in Taveuni affects us very much, and that was not brought up. The Vitoring Vonua, or how it can be interpreted back in the days, it come to law till today, and there hasn't been a review on that. And the Crown Grants, for example, where we are, we have a Crown Grant on the other side, and one that closes us off. Our community has been at a loss. It was not till the year 2000 that we were closed off. We couldn't access the public roads. We had, if it was high tide, we had to go by sea. And fortunately, it was through the SVT government that we had a road cut into our place. But we'd been trying. My father had been trying to get a road to cut through our place, which was not allowed by the freehold landowner. So I followed through with the Crown Grant history from at the National Archives, where we're trying to go back into the buyback scheme in order to buy back the land. We have an Indian community next to us, which we are very closely related to, and there are foreigners that close us off. And these are the issues I see, because the rise of in the criminal activities all around, we cannot blame the youth. We cannot blame the people, because the laws that restrict them even from going out to the seas and doing this, they do not have any rights. So we tell them what to do, and then they'd rather go into to do things at night. Maybe it's illegal, but that's their right. So I request if we could look at that, and gratefully that Mr. Waikula is very well informed of this. So we're trying to work with him into ways we can better the provisions that the government has for us.
Since there are no other comments or questions from the members to SWN Advocacy and Lavitira Vanua, Mr. Nawekula and Turagana Rokutidolo, Pinavalevu, from you and your delegation for your submission this afternoon. Thank you very much, and have a pleasant afternoon.
Just before we go, let me just address Section 48 of the Police Act, because that was raised to me to look at. And having looked at it, I agree with the Fiji women's rights people that you must remove the justices of the peace for the following reasons. They are not judicial officers. They do not possess formal legal qualification. They lack legal training necessary to evaluate complex evidence, determine reasonable suspicion, and balance police powers against constitutional rights. Such warrants can be used to investigate political opponents, activists, journalists, businesses, and others. If the threshold is lowered to the JPs to use them, there is a greater possibility of misuse and insufficient scrutiny. So, what, as an alternative, in cases of urgency, in remote area technologies allows police to obtain warrants electronically, so that can be done.
Thank you very much, Mr. Nawikula, for that submission. Navalia, you are excused, sir.
Thank you.
Timbul lebih nak tu, yuk. Baik. Thank you, honourable members. Please join me in welcoming the delegation from the Great Council of Chiefs, led by the chairman of the Great Council of Chiefs, Dr. William. Sir, it's a pleasure to have you and the delegation here this afternoon. Just for the convenience of those who are tuning in, please just do introduce your delegation and specifically which bills you will be speaking on. So without further ado, sir, you have the floor.
Honorable Mr. Chairman, honorable members of the committee, good afternoon. We are here to deliver an oral submission on the commercial use of marine areas and briefly on the Rights of Indigenous People Bill. If we may, we will provide a written submission on Monday morning to the committee. Thank you, Mr. Chair. To my right is the General Secretary of the Great Council of Chiefs, Mr. Iswakalomera, Mr. Olaim Bayo, who has been assisting us through consultation in the preparation of our bill, and Mr. Simeone, who is also a member of the staff of the Great Council of Chiefs in preparation. Mr. Chair, if we can proceed, mindful of that it's a Friday afternoon, we don't want to hold you for long. Just to set the scene, the observation on the two bills from the Great Council of Chiefs have come about following our consultation across the country. Unfortunately, we will admit we haven't finished it all. We've done 11 provincial, we've attended 11 provincial Mbose in gathering information and views of the Turangani members of the Mbose of those provinces. That's 11 provinces, 253 Tikina chiefs, who represent 584,363 members of the indigenous community, who have given their support to and have given us the confidence to come forward with this submission. We shall, if we may, Mr. Chairman and honourable members, proceed with, I'll give an oral brief on the commercial use of marine areas. I appear before you, gentlemen, today on behalf of the Great Council of Chiefs in its capacity as the apex institution of traditional leadership and customary governance in Fiji. At the outset, let me state clearly that the Great Council of Chiefs does not oppose the commercial use of marine area bill in its entirety. But its abiding wish is to continue and preserve the pursuit of the GCC, affirmed by the Queen in Her Majesty's Royal Dispatch of 1881, that Ngoli ownership must be recognized in the same way as customary ownership, owners own their land. We do recognize the need for a modern framework that provides certain certainty and investment, facilitate economic participation, and addressing long-standing issues surrounding the commercial use of marine areas. However, we do submit that legislation concerning Rualingoli cannot be viewed solely through an economic or administrative lens. For the Itaukei people, Ngolingoli is not merely a resource. It is an extension of the Vanua and encapsulates soil, land, and everything in it. The space firmament immediately above it and waters, including Ngolingoli. The synergies of these elements contributes to an inclusive definition. It is tied to identity, culture, stewardship, obligations for future generations, and the spiritual relationship between people and place. Our submission, Mr. Chairman, honourable members, therefore focus on ensuring that the bill is built upon foundations capable of enduring over time. The central question before us is not whether development should occur. The question is how development can occur while preserving the authority, dignity, and propriety interests of customary marine owners. The Council has identified three broad concerns, Honourable Chair and members. Firstly, the protection of customary authority. Now, while the bill recognizes customary ownership, many of its operational provisions place decision-making authority within administrative and technical processes. There is a risk that customary owners become participants in decisions about their own resources rather than primary right holders. The Council respectfully submits that customary authority must remain central throughout the process. Customary owners should not merely be consulted. Their legitimacy as original right holders should be expressly recognized and protected in the bill. Secondly, Mr. Chairman, the treatment of compensation. The bill introduces mechanisms that quantify marine rights for commercial purposes. While valuation is necessary, we caution against allowing compensation to become a substitute for customary rights. Customary marine interests are not created by legislation and should not be extinguished through payment. Compensation must therefore be framed in a benefit sharing arising from a use of customary resources, rather than the purchase of replacement of customary authority. This distinction is fundamental. Thirdly, Mr. Chairman, the concept of beneficial use. The Great Council of Chiefs notes that the bill seeks to promote productive use of marine areas. However, customary stewardship often includes restraint, seasonal clauses, tambo areas, conservative practices, and cultural protection measures. These should not be interpreted as non-use. A narrow economic understanding of productivity risks undermining indigenous systems that have successfully managed marine resources for generations. Honourable members, the Council also draws attention to broader institutional considerations. Where decision-making powers are concentrated within tribunals, administrative bodies, or political offices, sufficient safeguards must exist to ensure customary legitimacy remain embedded within the system. Procedural efficiency is important. However, efficiency should never come at the expense of legitimacy. Long after governments, ministries, and officials have changed, the Vanua will remain. The legislation must therefore be capable of protecting both present and future generations. The Great Council of Chiefs, Mr. Chairman, respectfully submits that the bill would be strengthened
by several targeted refinements. Please allow me, these include express recognition of customary owners as primary rights holders, stronger safeguards preventing compensation from extinguishing underlying customary rights, recognition of customary stewardship as a legitimate form of beneficial use, greater participation of customary owners in determining compensation arrangements, safeguards ensuring that contractual arrangements cannot derogate from core customary rights, stronger review and oversight mechanisms where customary interests are affected. These recommendations do not seek the delay of the bill, to delay the bill, rather. Rather, they seek to provide clarity and durability. Honourable Chairperson, the Council position is guided by a simple principle. Developed and customary ownership should not be viewed as competing interests. They can and should coexist. The objective should be partnership rather than substitution. The Council has previously advanced the concept of hybrid and partnership valuation. This approach recognizes customary owners not as passive recipients of compensation, but as integrational partners in the use of their resources. Applied to this bill, it offers a practical pathway to align investment, stewardship, and equitable benefit sharing. In closing, Mr. Chairman and honourable members, the Great Council of Chiefs respectfully encourages the committee to ensure that the final legislation reflects three enduring principles. First, that customary authority remains central. Second, that development must operate in partnership with customary ownership. And lastly, that future generations inherit not only economic benefits, but also the rights, responsibilities, and stewardship obligations that have sustained Fiji's marine resources for centuries. With those remarks, Mr. Chairman, I thank the committee for the opportunity to present the views of the Great Council of Chiefs. We welcome any questions. The Great Council of Chiefs is not asking Parliament to choose between development and customary rights. We're asking Parliament to ensure the development proceeds because customary rights are respected, not despite them. A bill that secures both investment, confidence, and customary legitimacy will be stronger, more durable, and better for Fiji in the long term. I thank you, Mr. Chairman.
Navalio Ratabilam Sirvakula, the GCC Chairman. Honourable members, are there any questions or comments on the submission from the Great Council of Chiefs?
Just one request, Chair.
Honourable Ustamati has one.
I'd like to thank the chairman of the GCC for his the three principles that he's outlined that I'd like to see in the bill. I think my request would be similar to what I'd ask Nico Nawekula. You have the principles there. It would really help the committee if you took some time before you gave your written submission to identify the various clauses in the bill, which using the lens of the three principles that you've come up with to say how they would be changed to reflect those principles. I think that would be our request. Thank you.
Through you, Mr. Chairman. Thank you to the Chairman of the Great Council of Chiefs. I would like to refer the GCC Chairman to Section 34, which I think it's on the screen. Some submittees, Chair of the GCC, had come and informed this committee that this Kuma bill does not clearly repeal the Surfing Areas Act of 2010. Reason being because of those sections 6 to 9, which is an exception to that, the repealing and saving. So this Kuma bill still has that section 6 and 9. So I asked the GCC if that can be considered as well, because I think one of the main areas the Ngoli owners wants the Ngoli back is because of that section 6 and 9, which is unfair to the indigenous owners. I'm requesting if that can be part of your written submission as well. Winak.
Honorable members, you've asked us 2 questions, and let me reply to them. One, first to Honorable Chole Usamate. We have, and we will include in our written submission, 13 sections of the Kuma Bill that we think runs contra to the principles that's been raised by the chairman. The problem we have, as you understand, we are talking about a property that has never been part of the economic matrix for Fiji since day one. So we have that recognition of an unidentified property, and now we're having commercial interest raised. So now we have a conundrum. We want to, the GCC stand is to identify the property first, vest it to their traditional owners, and then talk commercial development. But Kuma Bill, as you all understand, honorable members, is talking the other way around. It's an inversionary process. It says, we will recognize your ownership to this as long as you have these 2 activities allowed on your. So that's one. Number 2, it brings in a new paradigm to the integrity of the property itself. We haven't really looked into the inventory of rights within Ngoli, and it's different for every clan or every Ngoli ownership. So we haven't inventoried it. But Kuma is saying, if this piece of paper is your own Ngoli area and your commercial activity is here, then we will recognize the rights that apply here, but only for this area. Now, let me raise an important issue here. Customary rights, as you are aware, is not segmented or freezed as common law rights. So we have layers of complex relationship, obligations, duties, restrictions. These are all within, but they are not part and simple as the Kuma Bill points out. So our suggestion is, let's find a fulcrum where there is a balance between allowing development to occur, but also to respect those rights. At the same time, draw from the body of what's already available in international valuation standards how to value those rights. If there were 100 and we are using 4, what happens to the 96? And then number 3, no extinguishment whatsoever. And then let me go to your second part, section 6 and 10 of the surfing area. The surfing area, as you all know, was a misnomer. It was about surfing, but not really about surfing. It was about allowing the use of Ngoli area without paying compensation. So the act in its informal terms is about applying an act as if compensation applies. So that's, and we pay heed to the sections that you are providing us, and no doubt that will form part of our written submission when it comes to you by Monday. Thank you.
Any other comments or questions? Okay. Thank you. Since there are no other questions or comments from the honourable members, we'll probably just wait for your written submission that anxiously on Monday. Unless you have any other thing to say, the chairman of the GCC.
Thank you, Mr. Chairman. Can I briefly give a readout on our comments on the rights of indigenous peoples, and we shall give the written submission as well. Honourable Chairperson, honourable members, and Joint Parliamentary Standing Committee, thank you once again for the opportunity to present the views of the Great Council of Chiefs. The Great Council of Chiefs welcomes the government's initiative to domesticate the principles within the UN DRIP since a long term coming. The recognition and protection of the indigenous rights is an important step, of course, towards ensuring justice, dignity, cultural survival, and sustainable development for indigenous people in Fiji. The Great Council of Chiefs fully supports the intent of the bill, but submits several provisions require strengthening, which shall be illustrated in our written submission. And this will be expressed in the written submission on Monday to effectively protect indigenous rights in practice. Mr. Chairperson, I'll hand over to Mr. Bai if he has got any more comment.
Honorable members, I happened to be in New York in 2007 when this UNDRIP was enunciated by the General Assembly. 11 Pacific countries didn't sign, including Fiji, under the pretext that we were already nation states, indigenous nation states. However, 23 years come in, and I think the ratification through Parliament has been welcome. But UNDRIP, for UNDRIP, the submission that we will be writing, and it's on paper, is that UNDRIP must be used as a tool because within UNDRIP, I think the most important provision in UNDRIP is about FPIC. And FPIC is a medical term that was used in the early days of the American Confederation to safeguard First Nations Indian women from a fertility program that to cull their population. So that then FPIC came about. So it's free, prior, informed consent. The way we see it, there are at least about 12 subheadings of consent to be covered under FPIC that can be applied. And I think the legal test for that is whether an ordinary man can understand what's been in front of him and consent to it voluntarily by understanding everything that's been proposed. And that's, I think, a very simple legal test. So for FPIC, we believe there's nothing in Fiji at the moment in application that considers FPIC. That includes all the 39,000 of TLTB leases. The problem we have is they confuse between consultation and free, prior, informed consent. So let me give you an example. When you de-reserve a piece of land, you de-reserve from what's been a designated purpose for maintenance and support, you de-reserve, and then you lease. But under the current TLTB procedure, there is just one consultation, when in fact it should be 2 FPIC. And I stress that the GCC wants to use FPIC as a tool, because when there is a material change in the consideration for the use of a resource, like you have a piece of land which is agricultural lease, and you want to convert it to commercial use, there is an FPIC in its truest, simplest term of application. And in strengthening what we have already raised, and in terms of we've suggested that the importance of FPIC should be adhered to, and much of it will rest, I think, in the act under the action plan. Yeah, and the action plan will be between the GCC and the ministry, I think. Yeah. So we hope, apart from it won't take a lot of time, and we need to implement that as soon as possible, because from 2007 to 2023, that's 16 years, and a lot has happened, which brings into account the issue of compensation and extinguishment of rights. And another reason that GCC is very keen on EPIC, because all new policy that's been raised through to be used by nation states through the General Assembly or the UN for that matter, even the World Bank, they don't want to use the word compensation. They want to use the word benefit sharing. So everybody is streamlined into a tight little vacuum. But as you know, customary property is a sui generis property on its own. It's different. It's property, yes, but it's different because it is a property that is connected to traditional laws and customs, that is acknowledged and observed, that's in relation to the land. And then because of the layers, they say in sociological terms that a house in the village is connected to 64 other houses in the rest of Fiji. So that's the problem we have. And point number 3, GCC wants a stronger protection of lands, territories, and resources through the EPIC. That will be part of our submission. And harmonization, which is very important with existing laws. We were just noting through a very interim exercise that we will have to change a lot of, or synchronize a lot of legislation, including the Constitution itself, for EPIC to work perfectly. And we raised that, which is part of our written submission, is indigenous participation in decision making. Right now, I think the World Bank is giving monies for projects whereby they want to see part of traditional planning in the project planning, initial project planning itself. Second last is the role of traditional institutions. If the bill should recognize and respect traditional leaderships and structures, customary decision-making process, and the responsibility of indigenous institutions in cultural stewardship. And finally, effective remedies and enforcement. Because EPIC, as we see now, is a 10-section act bill proposed, and then there is a schedule of the UNDRIP, but there is nothing connecting these two. Although convention states that a schedule becomes part of that law, we would like to have expressly stated that these two are connected. And number 3, EPIC as it is, the bill for Fiji, 37, it just mirrors UNDRIP, but there's no, it's very quiet on implementation. So how do we operationalize these things? So that's also part of the action plan, I would think. But that's something we suggest this panel should consider very seriously. And ladies and gentlemen, honorable members of the board, here ends our submission.
Thank you very much, sir. I believe there are no more questions or comments from the committee. So on behalf of the committee, we thank you very much, sir, and for you and your delegation for coming in this afternoon. Nabaliv.
Naka.
Naka.
John.
Are there any other submittees? You can come forward. Oh, Naka. Nabaliv Sarah. Thank you. Good afternoon, and thank you for availing yourself to this public consultation on the various bills. I don't want to take too much time. You are As per protocol, please just introduce yourself, whether you're here on a personal capacity or on behalf of an institution. And please do inform the committee on what bill that you wish to make submissions on. Thank you. You have the floor.
Thank you, Mr. Chairman. Mbulavenaka, honorable members, and thank you for the opportunity for me to present today. I'm Chosai Tokoni, Program Manager of the Fiji Council of Social Services, and I'm here to present on behalf of the organization. As a member-based civil society platform in Fiji, representing over 400 community-based organizations and 10 national NGOs who serve vulnerable families across Fiji. I'll be presenting on 3 of the 5 bills that is before the committee, and those are the Commercial Use of Marine Areas Bill number 42 of 2025, the Fiji Police Bill number 12 of 2026, and the Statistic Bill number 11 of 2026. Each is distinct in its subject matter, but they are united by a single question that we beg to ask, and that is, does this law serve the people it is meant to protect? Our overarching theme, as we presented to the Constitution Review Commission, is bridging the gap between constitutional promise and community realities. Just a bit of background on FCOS, maybe for the benefit of those who might be listening. FCOS has been the voice of the communities and civil society in Fiji for nearly 70 years. We worked at the intersections of social policy, community resilience, and human rights. Our membership spans across non-government organizations, faith-based organizations, women groups, disability organizations, and community-based groups from every division in Fiji. Honorable members of the committee, I want to reiterate that our work is not conducted behind a desk. It is carried out in villages, on riverbanks, and along coastlines with the very communities whose lives are shaped by the decision made in this very committee room. First, on the Kuma Bill, FCOS comes before this committee not as a newcomer to marine governance, but as an organization with a documented evidence-based track record of advocacy on exactly the issues these bills seek to address. I'm being mindful of the time of this afternoon, gentlemen, so please allow me to share a few of our work that might touch or address parts of the 3 bills before you. So in 2021, FCOS, together with Jubilee Australia and Caritas Fiji, published a line in the sand, a report investigating black sand mining operations in Ba and Singotoka. What we found was deeply troubling. Communities in Ba told us they were never shown the environmental impact assessment in their own language. Women were excluded from consultations. Mangroves were damaged. Fish stock declined, and the communities most affected had no legal mechanism to say no. In 2024, FCOS commissioned the Monash University Climate Justice Clinic to review Fiji's legislative framework on deep sea mining. The report confirms something alarming. While Fiji speaks on moratorium on the world stage through the Udaune declarations, that moratorium has never been passed into Fijian law. Our Mining Act, as amended by Section 17A, already permits seabed exploration license. We are one minor legislative amendment away from exploitation beginning. We acknowledge and welcome the bold intent of this bill. The reversions of proprietary ownerships of commercial marine areas to Itaukei customary owners is a long overdue correction of historical injustice. For generations, our people have held the spiritual, cultural, and practical custodianship of our Ngolingoli. Yet, the law treats them as users, not owners. We commend the government for this vision. However, honorable members, the bill is currently drafted, contains 6 significant gaps that must be addressed. First, the bill transfers ownership of the seabed and subsoil to customary owners. But under the Mining Act, all minerals remaining the property of the state. A community could hold a vesting order over their marine areas and still be powerless to stop a mining company extracting minerals from right beneath their feet. We call on the committee to insert an explicit provisions that no mining license or seabed extraction activity may be granted over a vested marine area without the free, prior, and informed consent of the customary owners. Second, the bill delegates consent threshold to future regulations under Section 33. We have seen what happens when consent is left to administrative discretion. We saw it in Ba, and FPIC must be defined in the bill itself, conducted in Itoke, independently verified, and extended to all people who are environmentally, socially, or economically affected, including women, youth, and adjacent communities. Third, the bill has no requirement for a social impact assessment or cumulative impact assessment. We call for community-led social impact management plan funded by commercial operators to be precondition for any vesting order. Fourth, on Section 27, Section 27 allows the TLTB to deduct up to 25% in administrative fees before distributing funds to customary owners. This is excessive. EFCOS call for this to be kept at 10% or lower. We also call for a formal integrations of the Bosini Matangali and Bosevanua into the governance of vested marine areas. They must not be bypassed by quasi-governmental entities. Fifth, the bill must allow communities to designate climate no-go zone within their vested marine areas, protecting areas critical for food security, cultural continuity, and climate adaptations. We cannot allow a community to be displaced once by the climate and again by a commercial lease. Sixth, the CUMA bill must be accompanied by a legally binding national moratorium on deep-sea mining and by Mining Act amendments that return mineral ownership to a traditional landowner. Honorable members, those are the 6 gaps in the CUMA bill. If you allow me, I'll move on to the Fiji Police Bill of 2026. Of course, interest in this bill flows directly from our counter-trafficking in person or CTIP projects, our unmet legal need research conducted with the Fiji Law Society, and also our Wakambula Vano project on community resilience and traditional governance. This initiative has shown us repeatedly that the most vulnerable members of our community, the women, children, persons with disabilities, and rural communities are often the least protected by the very institution designed to serve them. We welcome the bill's formalizations of a community policing and the establishment of an independent disciplinary tribunal. Moving away from the 1965 Act is a long overdue. We bring forth 4 specific concerns to the committee. First, on community policing. Part 9 establishes community policing committees, but allow them to determine their own structure. Without statutory safeguards, the most vulnerable will be left out. Section 142 must be amended to explicitly mandate representations for women, youth, and persons with disability. This committee must also be formally integrated within the Mboseva Koro, Bosenitikina, Bosenesana, and Bosevanua, not run parallel to them. Second, on accountability, Sections 127 gives the Commissioner broad powers to summarily dismiss complaints internally. Any complaints involving human rights violation or excessive use of force that is summarily dismissed must be subject to mandatory review by the Disciplinary Tribunal or the Fiji Human Rights and Anti-Discrimination Commission. Furthermore, the quarterly public reporting of complaints under Section 160 must be disaggregated by division and gender so civil society can hold the system accountable in real time. Third, on the protections of vulnerable persons, Section 99 to 101 introduce consent requirements for forensic procedures involving children and persons with impaired capacity. But our CTIP project has shown that in rural areas, statutory rights are often just paper protection. We ask that the bill mandate the presence of an independent civil society representative or welfare officers during these procedures. This is part of the Justice Pipeline Framework that we propose to the Constitution Review Commission. Fourth, on jurisdictional clarity, the bill grants broad investigative powers, including covert surveillance. We ask that the bill explicitly ring-fence these powers. The police investigate, the DPP prosecute, and the anti-corruption oversight remains with the proposed fully resourced Accountability and Transparency Commission as embedded in our Constitution, and in their absence, as current, the Fiji Independent Commission Against Corruption. I'll move on to our submission to the third bill on the Statistic Bill of 2026. For FCOS, data is not just numbers on a page. It is the foundation of the social contract between the state and its citizen. Without accurate, inclusive data, we cannot measure whether a just minimum wage is working, assess the impact of climate change, or ensure that most vulnerable are protected. Our Kadivaka scorecard initiative depends on access to public data to hold institutions accountable. This bill directly affects our ability to do that work. We strongly support the intent of this bill to modernize Fiji national statistics systems and align it with international standard. The whole of government approach of data sharing is a step in that right direction. We bring three specific concerns to the committee. First, on governance, Section 6 guarantees 19 permanent seats on the Statistical Advisory Council to government ministries and statutory bodies, but civil society is only an optional invitee at the discretion of the chairperson. Civil society organizations and disabled persons organizations are not merely users of data. We are primary collectors of community-level realities. We ask that Section 6, subsection 1D, be amended to guarantee permanent seat on the Council for a representative of a national CSO body and a representative of a national DPO body. We must be statutory members, not optional invitees at the mercy of the chairperson. Second, on data disaggregation, Section 22 grants broad power to produce statistics, but the bill does not explicitly require data to be disaggregated. We cannot disseminate systemic barriers if national data treats our population as a monolith. We recommend a new subclause in Section 22 mandating that government statisticians disaggregate data by gender, age, disability status, and geographic location, rural and maritime versus urban. Disability and accessibility metrics must also be explicitly added to Schedule 1 as a prescribed matter. Third, on public access, the bill requires report to be tabled in Parliament, but lacks a proactive dissemination mandate. We ask that Section 31 be strengthened to require that all non-confidential official statistics be published proactively on a free, open access digital platform for civil society and greater public use. A modern Statistic Act must democratize data, not just streamline government data sharing. In closing, honorable members, the communities we represent do not oppose development. They oppose being developed upon without their knowledge, without their consent, and without a fair share of the benefit. Across all three bills, our message is the same. The law must bridge the gap between constitutional promise and community reality. The Kuma bill must protect customary owners from extractive industries. The police bill must protect the vulnerable from the very system meant to serve them, and the statistic bill must make the invisible visible so that no community is left behind because it was never counted. We are the custodians of this land and the ocean. We are not a distraction to development. We are the development. Nakavaliw for the opportunity to make this submission, honorable members.
Nakavaliw, thank you very much, Mr. Chisaya Tokoni, for making submissions on behalf of FCOS. Honorable members, are there any comments or questions? None? What's that?
I will submit a written submissions over the weekend.
Thank you very much. Mr. Tokoni, so on behalf of the committee, we thank you, and please do thank your organization for making submissions on the 3 bills. Nasar Valeu.
Nasar
Have a
Valeu.
blessed day. Are there any other submittees? Valeu. Na, Valeu, Sara.
Mike, nabili Mike.
Mapakangando sa kilani sa tiko si kena noa. Eu ngole sara mai na bono luoni. Na tango nume ya turani dolo. Kitu te bume kina na basa babalangi. Kitu sara basa mana babici. Tu basa tantura. Iya. Do basa cara turanga. Mapakangana nanu kumai tomana wala ngai sona. Tuku sambu tu Cina noa. Me bakangana bikau wari takatoka na ya kamembaleta na vilu tekini alo tambo. The leadership of the Holy Spirit. Okwe na non the foundation na.
Already taro bike munyelaka na lawa baturi da boni na bia bosa kine ni ko.
Obe na lawang au paturi membaleta ngana non tambula na ituki which non tambula na ituki which samai okenda samai dalata chuko dona non tambula na ituki kwenda ya butekin na ituki membaleta non dungarabana non takalu miliuta kenda na non na kena liuta non tambula
Turu eu tarungi toranga tonga onisa wilikau tinalawa baka tutu ni right of the indigenous people.
Au semberni wilika ngona nunggu we watutu ngango membaletanga nandundunu sikani nundunu ni tamata nandundunu ni kalumbula ko embuliken na tamata ko ngango na ko ngole chumikirango kanta sama idalata chuko na non dai tostos kina mene tegubuningo na tegubumikina na non dai tostos ngo may nanguna sa may didikina na didiba koloni. May nanguna ni ngunan da mambulumikina na ituki kay nanguna sa may lau kosumikina ko nang bulaba koloni. May takosumikenda may baka tumbo dito kina na nonday tostosa ni nondambula andambula kina na ituki. Ay ngali may nabunuluni. Nakena watawan ni walau endona watu ya ndurkina na donundonu limunan raw yang bagsauci.
Kau bengkor na balabu?
Na balabu. Okay. Korbal na balabu.
May nabosa
May nabosa. Ya na batungo na chigo e ndur milubun. Na kena tawanyo balabu. Batungo na nduri. Na batungo na nduri ngona angai deutiki na ndona sember na bola.
Pembengori kona kwa diuti na batu.
Diuti na batu.
Na tabi betu kuna turang matangali na buku sakadi batu balabu.
Na buku ni batu balabu. Na buku ngona na kena na yabutu ni tamata endambule burburungo. E chikibichi. E chusarango na ko ni lumenukor. E sinoro tabakaroro. Ona rawa tangona. Endre na kausa tukuno chino. Ni nandina nandung kini sapspa endrende me lurai endrende me kilai endrende me roachi ngone nangara endangara nandu nangula mendanangara kina mendangara buana kelumbula okoe pambula na yalo
iya matanggali na daba ni nabia na utu di kasaranga ketole biarong wala na utu di ka ngono bia ketole
biarong wala na kame kilau bichiri kuwa. Ni dua na kaya tukume na bunungu. En pandapa toki na kwa na bosongo. Na alo ni kalu ni katulu ni matanda. Na matanda bayalo. Enda na kila na matanda bayalo ke bakasa tandola ni katulu ni matanda. Your physical guy, spiritual is something important. Kwa tudala tachigungo. So nung una, ang sin may dona linuto o levena. Ang sin may taltala. O betukulingan ko, na nung pakasangkaran andina. O may tukunang ko nandina lo manibo nung go bichi. Tuikin hindo na kahi bimbi sarabiao. Kuena ni katulu ni mata. Kuna chukona ni alo ni kalu ni katulu ni matanda. Na matanda bagayalo. Enda nangai kila na matanda bagayalo. Keba kasatan dola ni katulu ni matanda. Ko tukuna chukini ndai.
Matanda
na alo tambo. Na alo ni kalu. O koe ntangarabi koe bagayalo. Sinangarabi koe bayango. Ni wambulok na alonda. O bichi ni kua. Isini nabunda wona kai bina katana wanda. Enda bakasangara wali buchuke nangunungu. Nakame butune nakame ndakani nakame ndangu. Butune usartungo bichi. Au kila na nungu hunua. Au kila na kai chukina. Maina ndelingele me ado sare mbotanera. Kochu na romanindo na kirito usaka uchi bikumdu. Kuena bole chukubuno sa urido china buno sa tukuni uchi biau na kambale tana buno chukina. Kuena boto
i matangali kito sakire moni na barita kamay na nakawye barita ka kilano sa taramay na bika bagayalo.
Iyo.
Kaya sa ngayon babi nakatagi kito sa babi bilang kira bagalebu.
Iyo. Matay ni kawye tukuna sa tukuno chungo na may na sikinano ni binakachina tuibichi kaya na lewena ko merachigo batal tuibichi. Orto na turang.
Oni kuti kumeni kwento na yato ni sabia bakatura mesa nonda tuibiti.
O sing ni binakata muda ka bangori. O binakatanga me daka nga indona bakanga wat kunongona. Merakau mo ira binakata merme mbolean tuibichi. Sera oira sa tiu me saba matata kena bikin narkai bichi. Indonun tuibichi. O sini binakata menduanga tutunga bango ta satunga nonta bakasa mas anda boleh. Metaka baka saba bikin sarana lewibich balatang ko ni nonda. Do na boso no bosta ka balang bikim do. Arivil take bio no chuma premista. Fiji is indeed the first country in the world to welcome sunrise every day. There is something special about being in a place where the day begin. Na umata-mata ngo, do na umata-mata dingitaki. The chosen one. Gayong ngole may na uira na tukanda, meron may chikoy na punongo. Wilikino, kenda saranda chiko. Menda baka samta ka pabimbi na non rala.
Imata na numuni batutu mendo na tuibiti. Kaya kali binakata.
Iyo. Batutu mendo na tuibiti.
Binaka. Wat kena bula bayalo.
Kena bula bayalo.
Naka. Daw tali.
Kena karua ko na kaya yado chungo nonda samai wasi na nonda bonua. Na kain do bedaka menda daka wendo na ba tulewa me ka kuni tumbukina na kodo tumbukina na bimba tumbukina na bingati ni sabe daka wendo na watulewa ngona mbimbi ni watulewa ni ndura tamata me paka me tibichi ka wir kena turanga au binaka tsumo na kakedi me nona kede wirito ke ia me ndunga na umangelera
Ndua taro. Oni sambole da kabut ndona muni batutu kina bosile baturang.
au sembera bandu ni au sini lewana na bosi batura
Lana via bano vina kamoni lai batura kina no muni batutu mbale tage banduri ndora tuibiti. Ena nga mera na le rongo da kede na turang
yo au bambote ni tiko ni simadala ni tiko me na nosenga au abara au pamadala tachu kan balatane tutu baturang o pamadala tachu na no vertu na chuin no membalatane tutu baturang kendo sa turang o kemundu kedendo na
Matagal kelas sama tatu pabina kasaranga bikito na kanibetu.
do sa kelas
Kito sa turang pabina kasaranga na bono ni bia boso to kamay kina membalata na batutu ni tukuniti umay. Kito nang kailay bital nota na mata kumitingo. Kito na lesu tala may bikya muni. Siya ni radibola tala may. Ni radibola kasaranga may. Bita may na bika ni binakata. Hena mata kumitingo. Kito sa nakeri muni sana nakabra no muni conclusion. Muni sana bakotie kini muni mamadala o klani tio taleng ruana marama.
Tanto
Kitu senta mito mo yung ko na matagalele o kimundo na kito na kap.
Kalau ngata, donu binaka. O papi ni binaka wali wikim do natura. Binaka wali mo. Hindi si kim do nangulungo. Namundu asudu mai mundu mendo ni nangulungo. Mundu ndambikin. Bos ni kawale mundu nding takike. O papi ni binaka wikim do. Dabi hindi ngitagi pa kalu. En nalo mani mata itu ndambikin ako. Tu bos na puno do ni nga emikin ya. Na puno din do bula do susumikin na pa ubale. Mondo umbula ci mondo ya tawani kwa. Dende sarci ona mbula wici. Binaka cikina na binaka. Sandende na binaka mendakila mendarawata. Sakuni kunende na binaka. Aruita ka mondo na pa binaka takwici. Ke mondo na wane. Do tiko mege vakau ngate ke mondo kuro.
Thank you very much, ladies and gentlemen. For those of you who are tuning in, we have our last submittees. So please just bear with us. Our last submittees here this afternoon. So, ladies, whatever is your preference, in English or in Itoke, that's fine. Whatever is your preference. So, as usual, please do introduce yourself. And if you are presenting on behalf of an institution or speaking in a personal capacity, and then you may proceed. Naka.
Naka. Naka. My name is Caroline Fisher. We are just being in the civil society. That's why we are here again and taking this time to say sorry for coming back, because I was thinking, we were thinking, when we went back, we really talk about what we had discussed. And we are happy to be here. I would like to address the Honorable Chair, the Honorable Ministers for the Standing Committee on Justice and Human Rights. Okay. Thank you very much for allowing the humble ladies to be here this afternoon for the clause that we've been asked. And on that token, I just would like to give a slogan, because I see that all of you are tired. And for that, just a short story about our submission. When we went this morning, the taxi that we went in took our submission. So that was the hardest thing that we had. So lucky we had just little things that we were able to put it up this morning. And the clause that we really had, that is the one that the honorable ministers did ask, for us to revise. And that was the one that we've been talking about all along, the clause 34. Can we just have that? Yeah. So that is the one that we really, can we just ask if they just put it up? Yes. Yes, the regulation of Surfing Areas Act 2010 is repealed, except for Section 6 to 9 of the Repeal Act, which continue in operation subject to this act. For the 2 weeks, we've been discussing about this regulation. And most of those we've discussed with, I believe they are also listers. And for me, I just told them that for this one, for my interpretation, and I believe you would be agreeing on this because it's the policy alone. That is about clause 34. It's policy alone. And in that, did agree with the power that that section has. And even though, like the wording, people don't really understand it. So we really take it down, right, even to the word appeal. We were explaining the meaning of appeal, repeal in that context. So to take up that repeal, and they were able to understand. And that is a power itself that were given, that were able for section 6 to 9 in that context, which is in operation, subject to that act. So for our submission this afternoon, we did agree. We did agree with the power, but not to meddle with the machinery of the government. It's a cautionary approach to all of this. That is our request and our understanding in terms of that section, if it would be considered, so people do not really has to say
Ms.
in
Fisher,
that
sorry,
context.
my apologies,
Yes.
Honorable Chair, through you. Would you like that section 6 to 9 to be repealed as well?
Yes.
Some say that section to be repealed.
Yes.
Would you agree we don't keep any exceptions in this new bill? We remove
Yes.
it? Okay.
We don't put it in that context. If it's a bill like section
You want
itself,
a new bill?
yeah.
Remove all the things under the surfing regulations.
Yes.
Okay.
So in that is our submission today for the machinery of the government. Precautionary approach to be taken in that. So bottom line is remove that section 6 to 7. Just put it as it is. That is how it should be done. Is it?
So the regulation of the Surfing Act to be repealed. That's it.
Yes.
All right.
So on that note, may the government do review every 2 years.
Continue.
2 years, so that the public understand the function, and or otherwise build a council in that manner. So that would be the way forward for that clause.
You need a council.
Yes.
Okay. To
re-look into, to be in place in order to look at what it's needed in the surfing rather than putting it together like that.
Okay.
So, understand.
Issues.
Yes. Because the government comes and goes. So that is our submission today. Just on that, we would like to thank you very much for for allowing us to sit again this afternoon and highlight or give our opinion on the evaluation that we have on the information that we giving or our submission. Thank you so much.
Navale Usara to you two ladies. Thank you very much. As you are the last presenters this afternoon, on behalf of the committee, I take this time to thank you. Firstly, thank you very much for taking the time to come back and do a submission. I'm not sure if the members can agree with me. We very hardly have women coming in and making presentations from civil societies. Mainly it's the major civil society organizations and women's movement. But for you two ladies, thank you very much. To those of you who are tuning in, the general public, via the Facebook channel and the Walesi platform. That concludes our public consultation for these 2 days. On behalf of the members of the committee and the Honourable Speaker of Parliament, our submission is now closed. Naka.